The reason why I'm going to talk to you about case law is, truth be told, that's all I can talk to you about. I can't talk to you about your profession. You can talk to me about that. But I can give you a legal framework that you can hopefully meld with your backgrounds, and that might give you some help when you're being asked to answer sort of medical legal questions. So Martin in Nova Scotia is important. Mr. Martin was injured in Nova Scotia. It was a work-related injury, and he had suffered chronic pain as a result of that. Now, the WSIB system in Nova Scotia treated chronic pain patients differently than they did other disabled persons. And Mr. Martin and a few other people had said that under Section 15 of the Charter of Rights and Freedoms, that was not fair to discriminate based on the type of disability. And what's really important is what the Supreme Court of Canada said about Mr. Martin's claim. Essentially, the Supreme Court of Canada, speaking as a whole, all 8 judges on this panel agreed that despite the lack of objective findings, that there is no doubt that chronic pain patients are suffering and in distress, and that the disability they experience is real. That's a very important statement. Remembering that the Supreme Court of Canada comments are binding on all lower courts and tribunals, and in fact has been widely accepted by lower courts and tribunals in Ontario. To date, I oftentimes see orthopedic surgeons telling us, no objective injury, no disability, thanks for coming out. Well, reality is that, I always say that the courts are probably 25 years behind society, and in fact, most of the orthopedic surgeons appear to be even further behind than that, respectfully, in their view of whether disability can happen in the absence of objective pathology. So the Supreme Court of Canada says it can happen, and in fact, that is the widely accepted view.